Thank you everybody for joining us today. I know everybody's got a busy schedule, so we'll try to make this webcast informative and give you some tips and tools to add to your tool belt. So the privacy and the data privacy topic we want to present today. Before we get started, I just want to do a brief introduction. So Sue is actually a senior manager in Focal Point with me, so I wanted to introduce her as well. Before we get started, a little bit about me. I have been a managing director for Focal Point for about 3.5 years now, primarily based out of the LA office. I do work primarily on the IT audit side. However, I do a lot of work on the information security reviews. That includes data privacy. I've done work with banks, healthcare, automotive, pretty much every industry. So I kind of see things from the lens of an auditor, and I'll hand it over to Sue, and she'll probably tell you more about her data privacy experience.
Hi, my name is Sue Yim. I'm a senior manager at Focal Point, working in the data privacy team in the San Francisco office. My previous work experience were both in the in-house internal audit in manufacturing technology industry and in internal audit advisory and consulting in various industries. I have been with Focal Point for over 2 years, working with various industries such as technology, retail, food services, financial services, and consumer products. My team and I have provided clients with privacy gap assessments, audits, remediation efforts, and helping them get compliant with Brazil, European, California, and Canadian regulations. In addition, we perform HIPAA assessments and third-party risk assessments. In the next slide, Raj will talk about why internal audit is important for a privacy program.
Great, thanks, Sue. So getting to the topic at hand, internal audit and data privacy, I think there's a whole host of people that have looked at data privacy outside of internal audit. You see a lot of talk about the CCPA, GDPR. We'll certainly discuss those as well. We'll also take a look at some of the other regulations that are being proposed within New York, within Texas, and other areas of the country. So this is not really a California-specific topic. It's really more broad, and you'll see more and more legislation being passed. In terms of internal audit, there hasn't been a lot of exposure yet because the regulation has gone into effect this year. So internal audit is going to have to play a larger role in terms of auditing data privacy. And so what we wanted to do is give you, like I said, some tools that you can utilize, and then a methodology and approach to be able to approach that from an auditor's perspective, meet their regulatory requirements, and then help the organization to also improve their data privacy program.
In addition, I'd like to add that IA's experience in scoping and identifying risks and the root causes will be crucial to helping assisting with the maturity of the privacy landscape in your company. So we hope to provide you guidance on how to achieve it. So I just wanted to add that please feel free to enter your questions throughout the presentation. If we have time, we will try to answer your questions, but if not, after the presentation, we'll try to answer your questions directly to you. So I'll go into the next slide in regards to, we have a pop quiz. So, sorry, I have a cold right now. So after I read the question, the poll will begin. So based upon your current privacy regulation, in which stage is your organization department? Start poll, please. A, we are beginning to create a data privacy program. B, we have created a data privacy program and we are working to mature that program. C, our data privacy program is mature and we are in the process of continuous improvement. So I'll let people kind of answer the polls. Okay, stop poll, please. So what we see is that most of you are actually working towards maturing your privacy program. So we hope that this presentation will help you with some of the areas you may have questions on. So next slide.
All right, thanks, Sue. So basically what the poll results show is that approximately 78%, 79% of you are either in the process of developing the data privacy program or maturing that program. As we go through this agenda, what we'll try to do is kind of address both sides of that coin, and then also kind of give you some tips to mature that program. So in terms of our agenda today, we'll start off with the legislations we talked about, GDPR, CCPA, but also make it more broad-based to cover other areas of the country. We'll give you an idea of what types of frameworks that you can utilize. Namely, I've used three personally. I've used the NIMIDI, the NICE framework that's done by IC Squared, and then also the NIST privacy framework. So those are the three that I've worked with, and I'll kind of go through ones that you can use in your internal audit department, develop your program, and then we'll talk more specifically about any takeaways from what real world examples I have and also what Sue has. Finally, at the end, I think Casey mentioned about the CPEs. So you can also reach out to us. Our contact information will be provided, and we can help you get certification or CPEs as well.
Okay, great. Thank you, Raj. So as you can see, there are a lot of news related to privacy. These are only the headlines from Q4 2019, and they come from very reputable media outlets like New York Times, Bloomberg, and Financial Times. This is all due to changes in technology and the numerous breaches making headlines. Consumers are becoming more aware because they see headlines related to breaches or have been impacted themselves with their personal data being compromised. And in addition, new regulations are being passed more frequently. To put it in perspective, in 1995, just 1% of the world had internet access. Today, that number has skyrocketed to almost 4 billion internet users worldwide. That's approximately, I believe, about 57% of the world population. So privacy is no longer just a concern for the certain industries like the payment card industry or healthcare or financial services industry. So you might ask, how has privacy been impacted by recent developments? Next slide, please. So as you can see, there are a lot of news related to privacy. These are, due to the COVID-19, the world grinded to a halt, and they did some impact to privacy. As you'll note, some regulations are being postponed with more emphasis on public health surveillance. And whereas some regulations will still be enforced due to scrutiny and privacy incidents that are appearing in the news. Like most recent developments, as you saw with Zoom, where more people are getting online and doing web conferences, there was a security and privacy concern. So as most employees started working remotely, the use of technology has actually skyrocketed. In March 2020 alone, there were 67 incidents worldwide. So the increased use in technology, and as technology continues to evolve, it'll be important that companies make classifying that data a priority. In the next slide, we'll go over the privacy landscape and what that looks like and why it'll be important that companies make privacy a key area of focus. Okay. As you can see that in the US alone, new regulations are cropping up and being passed more frequently. And we have noted that many states are also observing CCPA to either enforce new or update existing privacy regulations. There has also been talks about federal regulations to ensure consistency. This is also very similar to other countries. Some countries such as Brazil and Thailand had or will enforce regulations similar to GDPR. It is becoming more important that companies be proactive rather than reactive as new regulations get enforced. As reacting will, of course, like as you react to new regulations, you will have to change your company's operations each time. So like I mentioned, GDPR, CCPA had many influences to many countries and states. So the next slide, I'll talk about some quick facts about both GDPR and CCPA. So why is GDPR and CCPA a priority focus? Both regulations provide more detail on accountability and consumer rights. But what you may not know is that prior to GDPR, there was an existing regulation in Europe. However, it was outdated. So both GDPR and CCPA is more aligned to the evolution of technology due to the massive amount of data being processed, the explosion of digital marketing and social media, and predictive analytics. Companies are learning more about their consumers. In addition, companies are sharing more data than previous decades with third parties, which includes selling or using service providers. GDPR specifically called out the role of toller versus processor, whereas CCPA was drafted reacting to a third-party selling of personal data. In both regulations, they're holding more companies accountable for how companies use and also share personal data. In the next slide, I'll go over some key differences between GDPR and CCPA. Now, I realize like most of you are going towards maturity, so these might be a little bit something you already know, but I'll just give you an overview. There are similarities to both regulations. They have individual rights, but there are differences in how they define personal data, opt-in and opt-out requirements. And also CCPA, what makes it different is even though it's been in effect from January 1st, 2020, but companies are supposed to be able to look back and action on a request from January 1st, 2019. So why are these two regulations important to the U.S.-based company that does not do business in California? Well, GDPR basically has held U.S. companies liable if they process EU personal data. CCPA is focused primarily on only California residents, but like I mentioned before, more regulations are going to be enforced. U.S. and international consumers are holding companies more accountable, and it'll be more expensive to update your company's operations reacting to every new privacy regulation that is enforced. And finally, there's serious penalties associated with both regulations, which will be discussed in the next slide. Okay, next slide, please. And corporations are concerned because GDPR, the fines can be up to 2 to 4% of global annual revenue. Also, CCPA also has penalties associated with per violation by Attorney General, AG. And CCPA also allows individuals to bring class action litigation per incident. With CA's large population and the fact that the fines are per individual and per incident violation, this can add up. In addition, we are seeing more companies having many, sometimes in the hundreds, internal and external systems due to changes in technology. We also see that companies are engaging with more third parties where data is being shared, whether it's being through selling or through service provider. And finally, CCP has many specific requirements that companies comply. For example, consumer rights, implementing safeguards, and like having privacy notices, and even opt-out requirements. And each of these are counted as one violation act. So in a situation where a company has hypothetically shared 1,000 California resident personal data with third party, and they willfully did not do their own due diligence with that third party, the company can be faced with by the AG up to $7.5 million for one vendor who had a breach. In addition, individuals can bring class action litigation, which is $750 per individual and per incident in this scenario. And this could potentially be a minimum total cost of $750,000 in this scenario. And it could be greater if they actually have damages of greater. Already, we have seen few headlines related to GDPR fines that have already reached $100 million in fines, and more expected to come for CCPA now that is live, and they will be starting monitoring the regulation July 2020, which will look back from January 1st, 2020. And to be honest, there has already been 2 class action suits against one large CRM company and one large smart home device company, and they specifically spelled out CCPA in their litigation. So we do expect a lot more for CCPA. So now that you kind of understand the severity of the penalties, I'll go to the next slide for a pop quiz related to the fines. So after I read the question, the poll will begin. So how many GDPR-related fines or notices were issued in 2019? Start poll, please. A, 34, B, 52, C, 21, D, 16, and E, 89. Okay, I'll give it a few more minutes. Okay, close poll, please. Okay, great, thank you. So the correct answer was actually A, 34. 34 may seem small, but this is related to actual fines that were actually given. So I worked with a U.S. company that had a regulator come into related to an EU resident complaint. My client was able to produce like documentation, how they're monitoring their program, and also provide like what remediation steps that they are doing in regards to the resident complaint. So in the end, they didn't get a fine or a notice from regulators because they were able to prove what they already have and how they are remediating any kind of complaint. So in conclusions, regulators are still actively contacting many companies in regards to how they're being compliant with the regulations. So companies must be prepared. In the next slide, we'll do another pop quiz in regards to fines. Next slide, please. I think you have to close the poll. There we go. Okay. So after I read the question, the poll will begin. Which of the following reasons were included in the fines or notices to corporations in 2019 in regards to GDPR fines? Start poll, please. Okay. A, insufficient transparency and control and consent over personal data. B, poorly disclosing purpose for using personal data. C, sending direct marketing messages without consent. D, unlawful processing of employee data. Or E, all of the above. Okay, I'll give a few seconds. Okay, stop poll, please. So as most of you selected, it was answer A. I will just kind of discuss in detail what these fines were related to. A large U.S. technology company was fined by the France Data Protection Authority, DPA, for approximately $56 million. B, a professional sports league was fined by Spain DPA for approximately $280,000. C, a UK telecommunication was fined by UK DPA for approximately $131,000. And D, a large U.S. accounting firm was fined by Greece DPA for approximately $170,000. Now, you might think that these fines are, so you must not think that these fines are like dependent on the type of violations. Fines are related to the size of the company and how many EU residents are impacted. So in the next slide, Roger will speak to you specifically on how to manage a privacy program now that you know some key facts about the severity of non-compliance. Thank you.
All right, thank you, Sue. Appreciate that. Great overview, and I think that gives us a good understanding about the privacy landscape. Right now, we see about 3 questions are submitted. Go ahead and continue submitting your questions. We'll either answer those towards the end of this webinar or we'll get back to you personally. So in terms of the data privacy program, we understand the risk, we understand the severity of the risk. Now, how do we actually address that risk in terms of a privacy program? I think the key takeaway from this slide is that privacy and compliance are a small component. They're very significant, but they're not the only components in defining the data privacy program. As you can see from the slide, there is involvement from HR. Certainly IT is going to be helping to protect and define those control mechanisms. There's a huge impact for third-party relationships in terms of vendor assessments and what are you doing, for example, with your cloud services. Legal is going to be heavily involved. So there's even marketing. A lot of the times marketing is overlooked because they're the ones who are going to be collecting this private information. So when you do your risk assessment as an auditor, you want to make sure that you're doing it from a holistic operations perspective and not just looking at it, okay, I'm going to go to the data privacy folks and then I'm going to create my audit program. So that's not going to work. So I think Sue has actually helped to define a lot of these programs using this methodology. So I'll let her add to this as well.
Yeah, exactly. So like the privacy program is very new to most corporations, and it is due to a lot of the regulations that are coming into place. And what you'll kind of note from this slide is like some of these departments have had either never or had limited exposure to audits or regulations. So our experience as internal auditors would be bringing value by providing some sort of structure, leveraging our existing knowledge and our critical eye, and driving escalation of privacy risk to executives and the board.
Perfect. So in terms of operationalizing the program, what approach or methodology can we follow? The approach that I've seen works best is kind of what you see in the banks. So a lot of banks have three lines of defense in terms of when they look at information security. They look at IT, and then they look at compliance, and then they look at internal audit. That approach actually works pretty effectively in terms of data privacy. As you may or may not know, about half of information security requirements are driven by privacy. So it makes sense that we would want to follow a similar approach. It'll also be in sync with what information security is doing and provides the organization with exactly that, three lines of defense. So in terms of compliance and audit, they do play a kind of a distinct role. They're not they're somewhat overlapping, but really it's the compliance organization that has to establish the legal basis for collecting data and to be able to identify what information needs to be protected. There's that distinction primarily because auditors, as you may know, cannot become part of the control. So they have to provide independent evaluation, independent assessment. So while there is a opportunity for audit to work together with the organization, we'll talk more extensively about that. There are distinct roles to be played by IT in terms of implementing the controls for data privacy, compliance, and then for internal audit. In terms of audit particularly, some of the frameworks that I talked about earlier, the NIMIDI framework, there's the ISC squared, the NICE framework, and then there's the NIST privacy framework. I specifically put the NIST privacy framework here because from my experience that provides the best level of assurance from an internal auditor's perspective. I think it's fairly comprehensive. So I would recommend that. But if you want to discuss the others, I'm happy to have that discussion as well. So in terms of the first steps, what do we do in terms of creating the program itself? I think when you do the risk assessment, the main thing to consider is the data. If you don't understand where the data is, and you don't have a data classification program that goes along with it, you're really not going to be able to protect the privacy, and you're really not going to be able to meet those regulatory requirements. For example, New York's proposed legislation requires data minimization so that you are only keeping the data in the organization that you are required to keep. If you don't have a data classification program, you don't know where your data is, you're certainly not going to meet those regulatory requirements. So there's a very direct link between that. Obviously, if you don't know where your data is, you're not going to know which systems it's touching, you're not going to know which systems to audit. So again, it goes back to the data. So these are some of the things that we lay out in the benefits as well. Tend to go through that whole data life cycle of collecting, transferring, storing, deletion of that data. And then there are several entities that are going to be auditing this data. So you want to make sure that you're doing it properly. You're going to have, of course, internal stakeholders, external stakeholders. And I think from a CCPA standpoint, you even have the Attorney General that's going to be looking at this data privacy program. So you want to make sure that the data classification is done appropriately. So we talked a little bit about the Attorney General, who's going to be enforcing this. So class action lawsuits, that's a big area. I think in the legislations that existed prior to CCPA, I don't think there was as much class action activity. You've seen some of the bigger fines that are doled out. For example, I think there was a $5 billion fine for Facebook. So clearly, there is a significant business case. And we'll also talk a little bit about the executive stakeholders and their involvement in making sure the data privacy program is effective. So I'm going to hand it off to Sue. What we'll try to do here is we'll try to connect the dots for you and to kind of show you what works in the industry and kind of how to apply some of these tools and methodologies.
Thank you, Raj. So as we mentioned previously, that the privacy landscape is very new. Most companies only have one or very few people driving the privacy program. So what we found is that the privacy team has having limited resources, so they may base their privacy program documentation or information they already know. However, however, I want to emphasize it's important to have face-to-face conversations with all key departments. And as you saw in previous slide, it's a lot of departments. At one of my clients, they only had 2 people managing the privacy program. Through face-to-face discussions, we identified that one of their departments were collecting surveys on consumers, and they were collecting information such as name, email, gender, birthday, with month, day, and year, zip code, and then other shopping preferences to drive future sales. And it also turned out that they kept the results of surveys in Excel, did not delete the data, did not pass or protect the file, and also shared it with third parties without encrypting. So through our efforts of identifying the type of data that was collected, the company has stopped that practice and limited the type of questions asked in surveys. As internal auditors, we have been exposed to a wide variety of departments, and also we also have the skill of asking probing questions, which will help driving more accurate picture of the privacy environment. Again, we know that documentation does not always equal what is actually happening. So we just want to emphasize, like, it's very important, and it's going to be important to have that manpower team to actually talk with a lot of these departments. So in the next slide, Roger will talk about some key areas of focus of a data privacy audit.
Thanks, Sue. So I think Stu mentioned the importance of looking at the organization, and what the key focus areas do is they take the data as it's moving across the organization and identify key focus areas for your risk assessment and the data privacy program. There's a lot here on this slide. I think when you go through it, you'll find each of these could be a separate audit in and of themselves. For example, you look at number 12, which is the data minimization. That is a whole project by itself. But I think of these 15, the 3 that I think if I had to choose the top 3 that you want to start out with, the first one probably would be number 5, and that's the DPIA. That is consistent with the internal audit methodology. We really want to understand what the impact is of the data, kind of see what's in scope, what's out of scope. We don't want to make this a nebulous exercise where we're scoping in everything. So we want to make sure that we're doing the DPIA properly. I know Sue and I have done a lot of these, and in particular, when this is not done properly, then the scope really blows up and actually exposes the company to greater risk. So it's very important that the risk assessment is done properly. The second one I would select is probably number 9, which is the breach notification. This is directly tied to the legislative requirement that data breaches, they have to be notified to consumers within 30 days. And so that's something that's very tangible and is looked at by regulators, and you can actually be fined against it. So I would make sure that you have that in place. The third one I would select out of this list is number 15, which is the third-party risk management. The reason I select this is because it's counterintuitive. My work as an internal auditor, I do work with a lot of SOX clients as well. And so the SOC 1 is typically used for that, but SOC 2s a lot of times will try to address the third-party risk assessments, looking at what vendors are doing with your data. However, it's counterintuitive because a lot of organizations believe now they've moved to the cloud, they've transferred the risk to the vendor. However, they don't understand that a lot of the vendors aren't really doing their due diligence. For example, they may not be looking at their subservice providers. They may not be covering all the security controls as it relates to data privacy. So it really opens the organization up to a lot of this third-party risk. In addition, a lot of companies that I've worked with, they may or may not do effective controls around complementary user entity controls, which are the responsibility of the organization when they send the information to third parties. So there is a lot of risk there, and it's counterintuitive because you think you've transferred the risk when in fact you've basically increased it. So in terms of defining the program, creating the actual audit program, we wanted to give you a little taste of what the legislation looks like. So for example, for collection and consent breach notification, you see on your screen what the legislation looks like. This will help you to create the test procedures, will help you to make sure that you're meeting those requirements. In fact, we've gone one step further, and we've actually created control objectives and procedures that tie back to these regulatory requirements. Sue and I can certainly help with this exercise as well, because we've done this several times, and we've actually mapped out against the legislation what those control objectives and procedures should be. In addition, our control objectives are consistent with the NIST privacy, the privacy framework. So if you want to implement the NIST framework, you can still utilize the control objectives that we've developed. In terms of doing the audit and then kind of adding value to the organization, so auditors obviously have to be independent. They can't become part of the control, but there's a significant opportunity here for auditors to add value. I think it was Richard Chambers from the IAA who said that internal audit really should be a partner to the enterprise and not really an adversary. I think from that spirit, this data privacy program is an opportunity for internal auditors to provide really value-added enhancements that will add value to the data privacy program and will help executive stakeholders. We'll provide some specific examples. For example, if you look at the data classification program, data classification is the program itself is not really a requirement for the legislation, but if you don't have one, then you're certainly not going to have the regulatory requirements met. So that's one example. We'll get into other examples as well. In terms of findings, you want to make sure that you address the root cause. If you don't address the root cause, you're really not going to be making much of an impact. And if you can actually classify the impact of your audit findings in terms of laws, regulations, and dollars, is really going to help drive the change in the organization, be able to possibly secure funds for those that need it. For example, IT, they're really not going to get very far without the money. So really you have to work with the enterprise while maintaining your independence. And again, this is a great opportunity for auditors to become an integral part of the organization and to add value. So before I get ahead of myself, just wanted to add that the data subject and the consumer request requirements, those are actually a requirement, but as I mentioned earlier, a playbook is not a requirement, but that is another enhancement that internal audit can do to kind of help move the privacy program along. So when we're following through and we're creating the data privacy program, we're going through this iterative step of doing the planning, implementation, maintaining, demonstrating, and then we're doing this cycle. And as these enhancements are going on, we're iteratively helping the organization to mature and get better. So the key thing to note in this slide is that it's really a cyclical process. What we find is that as you're going through these enhancements and you're basically helping to create the program, helping to remediate gaps, you're going to find the technology changes, you're going to find the legal requirements change. So for those organizations that are still maturing, what we typically find is that doing this audit twice a year is effective in maturing the program. And for those that are like way ahead of the curve, it's usually once a year. So that's typically what we find works in the industry. And I think Sue is going to give some specific examples of the types of audits that we can perform.
Okay, great. Thank you, Raj. So as we previously discussed, there are two types of audits that can be performed. So I will discuss the distinction between the two. The full audit is more like what you might be familiar with in regards to entity level controls. And this is usually performed after a privacy assessment. This helps ensure that companies is monitoring and working towards remediating the gaps identified in the initial assessment. And assessments cannot be performed and forgotten. So you want to make sure that you have these full audits to make sure that the assessment has not been forgotten. The privacy landscape should be monitored because it will be important to understand how the company is keeping track of organizational and technological changes and how they're progressing on the remediation efforts from the initial assessment. The micro audit is more of a focus audit. So you should only perform micro audits once you confirm that a process is in place. There is no value in testing an area that's not ready to be tested. And as we mentioned before, documentation does not always equal what is actually happening. So the importance to validate the operational effectiveness of that key areas of focus. In the next slide, we'll discuss some of the key areas of focus that you might want to consider for a micro audit. The reason we recommend these six areas of focus are either due to how they interact directly with consumers, or they are specific requirements of both regulation. I'll go through each one of these and why. One, data subject request, DSR, it directly interacts with consumers, and it is a requirement. The mechanism must be in place. So please note, if your company does not have a strong DSR program, this is where complaints from consumers will actually escalate to complaints to regulators. So you want to make sure that your DSR program is strong. Two, PIA, DPIA, like Raj mentioned before, without an effective way for a company to identify changes to how the company is changing through organizationally or technologically, and how it impacts privacy, the information in the privacy program is outdated. Like we mentioned, technology is changing rapidly. In addition, DPIA, PIA also help identify areas of high risk so that it kind of helps drive remediation. Three, retention. Both regulations actually specifically state minimal use of data. What we have seen is often data is actually kept longer than necessary or actually indefinitely. This exposes companies to more risk, as having too much outdated, non-valuable information could be exposed to incidents, and also the cost of storage and making DSR requests more tedious than necessary. And even though CCPA only allows for 1 year, GDPR doesn't give a date. And so if you're holding information longer than necessary, you're going to have to action on that request. Four, consent. This is both directly interacts with consumers and in addition a requirement. And what we have actually seen is if you don't have a effective consent mechanism, one, it could lead to a regulation fine, but it also drives your DSR complaints. And like I mentioned before, you want to make sure that your DSR complaints are as minimal as possible. So you must have an effective consent program. Five, breach response. This is also a requirement. But I also want to emphasize it's going to be important to understand how your company identifies and actions incidents, because without a good incident response plan, this may lead to a company actually having a breach, which can drive significant fines. And six, as mentioned previously, third parties are one of the areas that drive both regulations. If you engage in a third party, your company does not perform due diligence on vetting them, especially surrounding privacy and security requirements. I know that many companies actually focus on security requirements, but what I have seen is a lot of times, like the third party assessments, when you initially onboard a third party, a lot of times it doesn't have anything related to privacy. And in addition, there may be some departments that might not actually use any technology. It might be just obtaining personal data from like your data warehouse or your ERP systems and sending the personal data to in CSV files. So they might not actually engage security even. So your company will be held liable with a maximum fine if it's found that you did not do your due diligence in vetting the third party. In the next slide, I'll actually talk to you about an actual scenario that we have experienced related to a micro audit. So we had worked with a Fortune 500 company in the food industry who actually had a really good privacy program on paper related to policies and procedures in place. But they actually got contacted by regulators because they received a consumer complaint from the EU. From an outside observer, they had updated their privacy notice that are aligned to GDPR. Their website looked like from a new perspective, it looked quite good because it shows their privacy policies right in the front of the homepage. But the regulators stated that their website was too complex. We engaged with them to review all their websites, and what we identified was that the company actually had too many ways for consumers to contact them, and it was in various websites of the home, like of the website pages. And so it was not always clear where consumers can go specifically for related to a specific question, even though the privacy notice indicated that it had where you could contact them for DSR requirements and your privacy questions, but they just had too many ways for consumers to contact them in various pages. And so, in addition, what we found was that email address and phone numbers were not even functional. So, based on our observation, the company updated their website and made one consolidated form where consumers can contact them. And so, because they were able to identify and then also work on what would be an effective way to make it easier, they did not actually get fined by regulators. So it's important to test your key areas of focus to make sure that they are operating effectively. In the next slide, Roger will talk about internal audit's role.
Thanks, Sue. As we begin to wrap up, I wanted to discuss about how internal audit can add value in this process. There are 6 key areas that internal audit can really add value to data privacy program. First is the accurate information mapping. A lot of this has to do with the fact that IT auditors, their work overlaps a lot with what information security and data privacy are trying to do and their objective. For example, in order for IT auditors to do their work, in order to define which applications and systems are in scope for IT internal audits as well as for SOX related work, they really have to be able to accurately map where information is coming and going. A lot of that will obviously hinge on the IT organization and the data mapping they perform, the infrastructure, how those applications are interacting with each other. But this has to be done for IT auditors to do their work. And this is the same information that data privacy will rely upon as well. So by actually capturing this accurately, IT auditors can really play a value-added role to the rest of the organization. Similarly, when they're doing their scoping exercise for internal audits or for SOX work, and they look at in-scope applications, they'll be able to tell which applications are now processing data that might be in scope for data privacy, or vice versa, which ones maybe are no longer being utilized so they can help with data minimization. So it works both ways. So that's another area that auditors can really add value. We talked about the gap assessments, making sure that along with looking at root causes for gaps that you find, that you're really adding value via, for example, we mentioned the playbook, we mentioned the data classification program. There's also a lot of other recommendations that we've made that are not directly required by the legislation, but again, add a lot of value to the organization. And then in terms of doing the risk assessment, it should be noted again that audit has to be independent. So really, IT auditors can't really rely upon the risk assessment done by data privacy, but it may be possible for data privacy to rely upon the risk assessments done by IT audit. So again, an opportunity for IT auditors to add value by doing a comprehensive risk assessment, not just looking at the data privacy organization, but really including marketing, legal, IT, HR, third-party risk, and doing that risk assessment that data privacy can rely upon. We looked at several issues with the vendor management and making sure that any risk that's transferred out of the organization is covered in terms of data privacy, what's being collected, who's processing that data, who's controlling that data. Have there been proper reviews done, for example, for sub-service providers? Has the organization done its due diligence in terms of looking at the complementary user entity controls? And then number 6, which is probably, I would say, the most significant, which is the privacy controls. So what you'll notice there is that you have controls like logical access, authentication, etc. And this actually directly ties to the NIST privacy framework. For example, identity management, authentication, and access control are specifically called out as a area within the NIST privacy framework. And a lot of those controls, physical access, logical access, remote access controls, these are going to be an overlap between the IT audit organization, and the Information Security and Privacy Organization. So there's really no point, and especially now with all the budget constraints, doesn't make sense to test the same control twice. So again, it makes a whole lot more sense for IT auditors to perform these tests, and then data privacy can either rely or reperform some of those control procedures, and there might be a lot of opportunity there to save money for the organization. And then I'd like to talk a little bit about the executive and the board level involvement. The reason that my work has moved a lot from doing a lot of internal audit and doing more and more information security type reviews, including data privacy, is because executives are seeing that the organization is impacted by data privacy, not only from a regulatory standpoint, but they really see it as a strategic initiative. You've seen Zoom lost market share and then gain it back again because of data privacy issues. Facebook, of course, faced the largest fine with $5 billion. So other than the regulatory side, there's reputational damage, which is hard to recover from. And then a lot of executives really are coming to internal audit and saying, how can you help me to resolve these issues, making sure that we resolve them before the regulators find them. And so this is where a lot of the drivers are coming from. There's a study done that about half of the organizations believe that the overall responsibility for governance of information security and data privacy resides in internal audit. So that kind of drives home the point that it is our responsibility as internal auditors to make sure that we're really adding value to the organization, and it will really help the executives to basically sleep better at night. A lot of the audit committees will roll up to the risk committees, and then they'll obviously roll up to the board of directors. So this is an opportunity again to add a lot of value. Sue will go through some case studies and then we'll wrap it up for today. If you'd like to add some more questions, we'll be happy to answer them now, or we'll get back to you.
Okay, thank you, Raj. So you might ask yourself, if you're a service provider or if you have a relationship with service provider, why is an audit program needed if they don't directly access personal data? Like I mentioned before, companies are being held accountable for breaches identified with third parties where they share data. So more companies are doing their due diligence on third parties they engage. In addition, as companies are held more accountable by consumers, they want to engage with third parties that support them regarding some of the privacy matters, such as DSR requests, having security safeguards in place like encryption and data retention. And platforms must have considerations related to privacy, like for access or deletion requests. Many of the companies that I work with are making sure that the third parties they engage have a privacy program in place. And I have seen that my clients have actually terminated relationships due to the fact that third parties are not working with them. And so it's going to be important to make sure that you are diligent with who you engage in third parties, even if they don't have direct access to personal data. The fact that you're passing along that data, it makes you accountable for how you're sharing and making sure that you're accountable. Because if you don't show that you're doing due diligence with third parties, you are going to get a maximum fine from the AG and regulators, the DPA and stuff like that. In the next slide, I'll talk about another scenario related to privacy program. So you might be asking, what if there's a HIPAA program in place already or any other program in place? Although HIPAA has some similarities with privacy consideration, however, it will be important to make sure that a company in healthcare has a privacy program in place. Due to the healthcare industry undergoing significant changes in technology, more scrutiny needs to be done. In addition, often with HIPAA assessments, most companies only perform assessments once per year, and also it does not go to the level of scrutiny as an audit. We often see that HIPAA assessments sometimes only review policies and procedures, or only a few samples are selected. With limited testing performed, it might not capture all systems, all third parties, or all activities that process patient information. I've actually had a scenario where I've had a client who done multiple HIPAA assessments, but because we did more strategic sample selection, there were instances where some systems were not tested. And so there's a lot of limited testing in regards to HIPAA assessment. And so, for example, and in addition, we've also seen where like a private HIPAA assessment was performed, and a lot of times the systems have more data than necessary. And so, like we mentioned before, even though documentation does not always reflect actual operation, and deeper scrutiny is needed to identify areas of risk. And so HIPAA assessments alone shouldn't be the only primary comfort level you have in regards to a privacy program. It's going to be important to have a privacy program so that a DPIA is going to be important, because it's going to help you understand where your risk is, and also help you in like mapping where that risk resides. And so in the next slide, I'll kind of recap some of the things we spoke about in today's presentation. So in summary, it's very important to maintain continuous monitoring of privacy program. Technology is continuously changing rapidly, and it's very important to validate the privacy program. In addition, internal audit can provide significant value by reporting risk to executive and board members on privacy concerns, and also provide value-added recommendations. To help your team gain more knowledge, it'll be important to be a member of the IAPP, or maybe get a certification, or referring to like the regulatory like websites and resources. So I hope this information was very helpful. Next slide, please. And like we mentioned, I think this covers some of the questions that were asked, but we are in the process of CPE. So if you have questions in regards to CPE credit, you can contact this email here. Also, if you want to get a copy of this presentation, or have any other have questions in regards to the privacy framework, or any other questions, you could actually directly contact us through our emails on this slide. Thank you.
Thanks, Sue. Yeah, and just like to add that for the NIST privacy framework, if anybody would like a copy of that to help create the data privacy program, we'll be happy to share that with you as well. Casey is going to be helping with some of the CPE credits, but if you have any questions or concerns, you can also reach out to us. Our personal email address will be included on the slide deck as well.
Okay. Thank you very much.